Okay, so this is the last panel today, and of course it's the most important, right? I say that only partially kidding, because it's, I mean, you can think about it as hitting on a lot of the themes we talked about today. If the background was sort of questions about ultimate democratic legitimacy and about culture shifting, I think some of those questions are implicit in this panel. But the aim of this panel is quite simple. It's to understand the meaning and the reach of that last sentence of all of our post-Civil War amendments. So they all, in essence, say something like, the Congress shall have power to enforce by appropriate legislation the provisions of this article. And what that means, of course, has been hotly contested. Most of our historical records suggest that the idea was that Congress was going to be the primary enforcer of the guarantees of the Civil War amendments, but the court moved away from that very rapidly, as you all know. And the idea of vigorous articulation and enforcement power, I think, reached its zenith in the 60s under a series of decisions I just called the Katzenbach decisions. Of course, they were all about voting rights. Voting rights really is the thing that is our theme that kind of pushes congressional power. But we see in more recent decisions, of course, of the Rehnquist courts, from which you're all familiar, City of Bernie v. Flores, and then the decisions in the context of the 11th Amendment, which defined Section 5 power quite narrowly. Now, the court in recent years, as you all know, has seemed to be moving away from some of the decisions that most narrowly read Section 5, and recent decisions, for example, sustaining the Family and Medical Leave Act, and also in the context of at least part of the public accommodations provision of the ADA. But the question is, where are we going? How do we understand the meaning of it, of the enforcement powers, and how do we think about this in the context of some of the themes that we've been talking about today? So I'll stop talking now and leave it to our panel, and then ask a few questions and open it up for questions. So first we have Michael Curtis from Wake Forest Law School.
Thank you very much, and thanks to the sponsors and all the people who have done a wonderful job of organizing this symposium, and particular thanks to those of you who are still here on a Friday afternoon. I'm going to talk about the 14th Amendment, and I'm going to talk about enforcement of the 14th Amendment, and I'm going to talk about it with reference to state action. And so you notice, in terms of what I've got up on the board, is the 14th Amendment. But what is what's left out? What's left out and what's up on the board is the enforcement clause, which says basically Congress shall have the power to enforce the provisions of this article by appropriate legislation. Why is it left out? Well, because during the period of history I'm talking about, to a great degree it was removed. I want to talk a little bit about the 14th Amendment. There's the citizenship clause. If you look back at the rich history leading up to the 14th Amendment in the years from the 1830s, 1860s, really there is a lot of discussion about the rights of American citizens. And often it's in response to mobs suppressing free speech rights. It's in response to the killing of Elijah Lovejoy, the anti-slavery editor, and so on. And people have this very weird idea. They have this very weird idea that we, as citizens of the United States, as a result of our citizenship, have a right to free speech and free press and these other things. Of course, is this consistent with Supreme Court doctrine at the time? No, it's not. And then, of course, you have the Privileges or Immunities Clause, which I understand to encompass the rights in the Bill of Rights. And this was a big deal because of the suppression of civil liberties and free speech in the years before the Civil War in the interest of protecting the institution of slavery. And then the Due Process and Equal Protection Clause. As I understand from reading the history of the 14th Amendment, the Equal Protection Clause has two aspects. One aspect is much like what we understand it about today. That is, prohibiting irrational classifications or caste systems or that sort of thing. So classification is really part of it. But another part of the idea of equal protection is just what it sounds like. People have a right to be protected by the law. So states are not to deny anybody equal protection of the law. The meaning of that, or the converse of that, is states have a duty to supply equal protection of the laws to people, to all persons. It doesn't matter whether you're a citizen or not a citizen. Everybody's got a right to be protected by the law. So the 14th Amendment goes through an evolution. In the first part of its evolution, the proposal is Congress shall have the power to secure privileges, citizens of each state, the privileges and immunities of citizens of the United States, as the author reads it, in the several states, and to all persons equal protection in life, liberty, and property. A lot of people support that, but a lot of people are very nervous about it. And they're nervous about the equal protection provision because they say, if we take this literally, Congress could legislate. Life, liberty, property encompasses everything the states do. Congress can legislate on absolutely everything and preempt the states. The other objection to it is, look, if all we give is congressional power, if the rebels return to power with their Democratic buddies, then they'll be able to wipe all of this out. So you end up getting the current version of the 14th Amendment. The southern states reject it. And Congress puts through Reconstruction, basically reconstructs the state governments. You've got manhood suffrage in the South, which means the blacks get to vote. You have these new state governments, new state constitutions that have to be approved and so on. And then what happens? One thing that happens is you have majority rule, real majority rule. You have a white-black Republican coalition that controls almost all of the southern states. And the response to that is Klan violence. There are various responses, but one is Klan violence. And so what you have is, and as you have killing people, burning their barns, shooting their animals, whipping them, threatening them, if you don't leave the state, we'll kill you, that sort of stuff, going on throughout the South. And when you read the debates in Congress on what's going on, they're very clear. You know, this is not simply a question of minority rights and the rights of blacks, although obviously it's a big problem for black people. What's going on is affecting white people as well as black people. The Klan is equal opportunity in terms of shooting and whipping and that sort of thing, because they're trying to basically use violence to change the political system. So Congress passes various laws in an attempt to deal with this. And they recognize if you're able to dislodge the black-white Republican coalition in the South, you're going to get a government which is going to be very bad for black people for a very long time. And that's of course, what happens. Americans of African descent do not come out well as a result of what happens. So Congress passes laws. And it passes what's the equivalent of 1983, well, even before that, it passes two types of laws. One type of law in 1870 is if groups of people band and conspire together for the purpose of punishing people for the exercise of their rights, privileges, or immunities under the Constitution, or to deter them from exercising them, they're guilty of a crime. This reaches private people. And then in 1871, they passed another law that says if private people band and conspire together for the purposes of depriving people of equal privileges and immunities and the due and equal benefit of the law, they're guilty of a crime. And then there's the 1983 provision, which is if people act to deprive people of rights secured by the Constitution and rights, privileges, and immunities secured by the Constitution of the United States, they are liable to be sued. It's sort of a constitutional tort provision. So there are these provisions. They're undercolor state law provisions, and then there are provisions attempting to reach private persons. All of the provisions that try to reach private persons have a specific intent element. They're all reach people who are doing these things for the purpose of depriving people of their rights, privileges, or immunities, or equal privileges or immunities, or equal and due access to the laws, and so on. What happens to this, of course, there's a big debate in Congress. Does Congress have the power to do this, particularly as to private people? And overwhelmingly, the Republicans who framed the 14th Amendment vote yes. And they have two theories, two main theories. One theory is the equal protection theory I mentioned to you, that, okay, states have a duty to supply protection. If their Reconstruction governments were unable to do it, but if they're unable or unwilling to do it, then Congress can act. If you think of current Supreme Court doctrine like Morrison, where you have to have congruence and proportionality, and you got to go judicial district by judicial district to enforce it, the Republicans reject all that. They say, look, we've got this broad congressional power. We get to decide what's reasonable, and we can pass this law to deal with nationally, to deal with the problems we have, and prophylactically to prevent similar problems. So one answer is they rely on equal protection to deal with the argument in the other direction, which is the state action syllogism, right? The 14th Amendment limits states. Klansmen are not states. Therefore, you have no power to legislate against Klansmen. It's very simple, crisp, clear, and so on. So that's one response. The other response is based on the Fugitive Slave Clause and the history of the Fugitive Slave Clause and what the Supreme Court did with it. Now, I've put the language up there, and then I've given you what I think is a plain, reasonable reading of it. The language says no slave, well, I'm getting rid of the euphemisms, no slave held to slavery in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such slavery, but shall be delivered up on the claim of the slave owner. Here's, I think, what I've paraphrased it, I think means just the same thing. No state shall, by any law or regulation, discharge a slave held in slavery by the laws of another state and who has escaped from that state, but the state shall deliver the slave up to the slave owner. Notice what this is, as the Republicans in the Congress that are passing these anti-KKK laws see it. This is a limit on states, right? This is a limit on state action. This says if you're a state and you have somebody who's a real slave and they escape into your state, then you can't, by law or regulation, set them free. What does the Supreme Court do with it? They say, well, from this Article 4 provision, we can infer that this guarantees the right of the slave owner to get his slave back. And because he has the right to get his slave back, therefore, Congress can legislate to make this right effective, and in doing so, it can reach private persons. So from this limitation on state power, we can infer a right, and we can reach private persons. Well, if you go back to which I haven't, if you go back to the 14th Amendment, you see John Bingham and other people's argument about that. They say, look, this limitation on the states, protecting all these rights and liberties of American citizens, and it's also, we have it in the Bill of Rights too, this is a recognition that people have these rights. Because they have these rights, they can be enforced. Now I think there are federalism problems with this if you read it too broadly. But the Congress did not. Okay. The Congress did not read it that broadly. The Congress limited it to actions taken with the specific intent to deprive people of constitutional rights. I don't think there's any serious federalism problem with that. And I would argue in favor of this result. You just don't have to look at the 14th Amendment. You could look at a structural approach to the Constitution. What's it supposed to do? Are we supposed to have a government in which private mobs can kill and shoot and beat people to keep them from participating in the political process and turn majorities into minorities? No, this is contrary to the whole genius of our government. Or you could look at the Guarantee Clause. You could put these things together, and the court should have found power, but they didn't. And in Slaughterhouse, basically, they get the Bill of Rights. Slaughterhouse and Cruikshank, the Bill of Rights are read out of the 14th Amendment. The state action syllogism is read into the 14th Amendment. The ability to enforce the 14th Amendment as to attacks on private persons that you can't prove are race-based is pretty much written out of it. Well, that sounds pretty helpful until you begin to read what they say. Like if you look at Bradley and Cruikshank, he says, well, of course it could be they're doing this to people not because of their race, but because of their politics. Well, gee whiz, yeah, that is what was going on. Two more points, and then I will sit down. In cases like Morrison, you have the Supreme Court citing these cases like United States versus Harris, with approval as to why the state action syllogism is a good thing and you need to have these limitations. What happened in Harris? In Harris, it's a white guy. You have a lynch mob that comes to the jail for purposes of beating up and lynching the prisoner. And so he's prosecuted. This is denying him the due and equal protection of the laws and so on. And the court says, oh, no, there's no state action. You can't do this. But this is one of these specific intent things. So you should be able to do it, I would argue. And in United States versus Morrison, the Gender Violence Act, if you injure somebody or, harm them because of gender bias, not generally, the law says you should be able to have a cause of action for that. And the court's answer is, oh, no, you can't do that. You can't do that because, first, there's the state action syllogism. And even if you could remedy it under this state neglect theory, you've only proven that 21 states have this problem, and you haven't proved that it exists everywhere. If we had a better understanding of these loathsome decisions after Reconstruction, which made it possible to engage in essentially coups and political violence and terrorism, if we had a better understanding of those decisions, courts should be embarrassed to cite them with approval.
Thank you. Next, we have Steve Calabresi of Northwestern Law School is going to tell us about what does the enforced by appropriate legislation clause mean?
Thank you. It's an honor to be on such a distinguished panel at the ACS annual conference, and I wanted to make 4 points about Section 5, inspired in part by my thoughts about City of Bernie against Flores and subsequent decisions that have followed it. First, I want to agree in talking about City of Bernie with Judge Michael McConnell's opinion expressed in the Harvard Law Review that one of the key flaws with City of Bernie is that it was such an overly judge-centric case and was wrong insofar as it suggested that Congress could not equally with the court interpret and enforce the Constitution. Our Constitution is unique among modern constitutions in that it does not empower a particular entity to interpret or enforce it. In that respect, the U.S. Constitution differs from, for example, the German Constitution because it does not contain a judicial review clause that assigns the power to enforce it to a particular court. And so the power of judicial review has to be deduced from the fact that the Supreme Court has the power and the obligation to decide cases faithfully to the supreme law of the Constitution. Marshall's argument the argument in defense of judicial review, I think, makes it clear that Congress also has the power and duty to enforce the Constitution. Congress, after all, has the legislative power, just as the court has the power to decide cases and controversies. And when Congress is legislating, it therefore has to interpret the Constitution, and it's totally appropriate for it to do so. Early in American history, Congress often debated and decided constitutional issues, and it continued to play the same role during Reconstruction, the New Deal, and the Great Society as well. So I think Congress's Section 5 power is a substantial power, and that Congress does have the power to interpret the Constitution de novo when it is passing laws pursuant to Section 5. The second question is then, how much deference should the Supreme Court give to Congress when it's interpreted the Constitution under Section 5? Judge McConnell, in his essay on City of Bernie, argues for a lot of deference. He analogizes the Section 5 context to Chevron and says that we ought to give as much deference to Congressional Section 5 legislation as the courts give to administrative interpretations under Chevron. I disagree with Judge McConnell that the standard of review for Supreme Court invalidation of Section 5 legislation is as stringent as that. It seems to me that just as the text gives Congress the power to enforce the rights created by Section 1 through appropriate legislation, it also gives the court the ability to judge in a case or controversy before it whether Congress has done that. So I think that a view of Section 5 that says that Congress can interpret it subject to a rule of clear mistake is as erroneous as the judicial supremacist view that only the court can interpret Section 1. Both branches, it seems to me, ought to be able to interpret Section 1, and they do so. It's often argued that in Section 5 cases that the framers of the 14th Amendment understood the Section 5 power very broadly in the way that Chief Justice Marshall had described congressional power under the Necessary and Proper Clause, and that therefore the court, when deciding Section 5 cases, should use a similarly deferential standard of review. I disagree with that because Marshall in McCulloch never had to deal with a key provision of text which is present in the 14th Amendment, and that is the presence of the words "to enforce." Congress has the power to enforce Section 1 with appropriate legislation. And it seems to me that the verb "to enforce" is at the very heart of the Section 5 power, as the City of Bernie Court argued. If one tries to think about what was the original public meaning of the verb "to enforce" in 1868, one source one might consult is Noah Webster's 1828 authoritative dictionary of the English language, which was widely in use in the 1860s. Webster defines enforce as to give strength to strengthen, to invigorate, to put in execution, to cause to take effect, as in to enforce the laws. It seems to me clear from reading Webster's definitions that the power to enforce Section 1 in Section 5 is not a power to rewrite it. This sense is confirmed in the Barnhart Dictionary of Etymology, where enforce is described as coming from the Latin roots in, meaning make, and fortis, meaning strong. So to enforce something as a matter of original public meaning is thus literally to make it stronger, not to change its meaning. This, I think, explains to me why Justice Harlan's dissent in Katzenbach against Morgan was right as to the ratchet theory of footnote 10 in Justice Brennan's majority opinion in Katzenbach. I think one doesn't enforce or make stronger Section 5 of the 14th Amendment by changing its meaning. Some might object that the weight I'm giving to the original meaning of the verb "to enforce" is not supported by the legislative history, as I discussed, but there are two responses to that. One is that the references in the legislative history to McCulloch aren't relevant because McCulloch didn't involve a text which had a "to enforce" limitation on it. And the second objection is that I am skeptical about legislative history for the reasons that many original public meaning originalists are skeptical about legislative history. It seems to me that it's the text which is enacted as a law. It was the text that was presented to the states and to the people for ratification, and so it's the words of the text that are the supreme law. I wanted, in my next two comments, just to say something about the problem that Michael was just talking about. And so moving beyond City of Bernie, I wanted to talk briefly about Congress's Section 5 power to pass laws like the Violence Against Women Act. The Supreme Court, as you know, struck that act down in Morrison by a 5-4 vote, and I think the Morrison opinion is dubious for several reasons. First, I think Congress does have the power to legislate against sex discrimination. and was doing so here. Second, I think that Congress did compile a lot of evidence that violence against women was and is a huge problem that the states were not dealing with adequately. And third, I think the Court's view in Morrison that there was no state action in that case doesn't hold water for some of the reasons Michael was saying. I think that Section 1 of the 14th Amendment does ban discrimination in the making of laws in the Privileges or Immunities Clause, as Michael and others have talked about. It also bans discrimination in the enforcement of laws with the Equal Protection Clause. And the Equal Protection Clause, I think, is a clause that is about the protection of the laws, not the making of them. And it says that the states must not only not discriminate in making laws on the basis of a suspect classification, they must also not discriminate in the protection of the laws by enforcing in a discriminatory way the facially adequate and neutral laws they have on the books. So it's not just enough to have laws on the books that ban violence against African Americans or women if those laws go unenforced. And where there was private violence against African Americans in violation of state law and the state law was not being enforced, Congress could and did create supplementary federal remedies. It is true that the state action here was actually inaction in enforcing laws against violence for the benefit of women. But since I think the states are under an affirmative obligation to provide women and African Americans with equal protection of the laws, there was a violation of the Constitution nonetheless. The Constitution is, for the most part, a charter of negative liberties, but it's not exclusively so, and I think the Equal Protection Clause does impose some enforceable affirmative obligations on the states. The fourth and final point I was going to make, which I will save till the question period since I'm out of time, was to respond more directly to Michael on whether Congress can use the Section 5 power to legislate directly on private citizens in context where the protection of the laws is at issue. And there, I'm not persuaded, but I think he's raised a lot of very interesting arguments against the Court's case law, and I think the Court ought to be open to reconsidering some of that case law and rethinking it in light of the arguments he's made.
Thank you. Next, we have Debo Adegbile, who is Director of Litigation at the NAACP Legal Defense Fund.
Thanks, Alati. I want to begin with a personal reflection. I haven't been to Philadelphia for a long time, but the last time that I was in Philadelphia, I was dropped off at the 30th Street station by Judge A. Leon Higginbotham. That was about 10 years ago, and at that time we were working on a case together. I was a young associate at Paul Weiss, and so I was pleased to see the judge's portrait as I came up the stairs. He was a great inspiration to many young law students and lawyers, and probably some older lawyers and probably law students as well. And he spent lots of his time here, so I thought it was appropriate to remember the judge. Pam and I worked with the judge on voting cases. And that's my topic today, actually, to share a little bit of a view from Capitol Hill and from the courtroom about the enforcement powers and how these Bernie cases have played out in the real world, or shall I say are playing out. My principal focus will be on the Capitol Hill part because the courtroom piece is now before the Supreme Court, and I don't want to handicap too aggressively the outcome, though I have a strong feeling about what it will be. Bernie presented a series of serious questions when the Voting Rights Act reauthorization began in 2005. It was shortly after the 40th anniversary of the Voting Rights Act, and so the country had focused on the extent to which the Voting Rights Act had been central in helping us move from the time of disfranchisement to the time of greater inclusion, and inclusion along many levels, I guess, not only for African Americans, but certainly for Latinos and Asians. The principal focus of my remarks will be on Section 5 of the Voting Rights Act, which is the preclearance provision. I don't have too much time to describe it in detail, but the short version is that That provision is one of the core provisions of the Voting Rights Act. It's a non-permanent feature of the Voting Rights Act. It covers all or part of 16 states, and it essentially is focused at trying to prevent a worsening of position for minority communities. That's the short version. Many of you know it well. Others don't know it as well, but it's had an interesting history in the courts and in Congress. The interesting thing about Section 5 of the Voting Rights Act is that because it's a non-permanent provision, every so often Congress has to revisit it and see how it's worked. In 2005, it was the fourth time that Congress had occasion to do so, and the first time it had occasion to do so after Bernie had been decided. And at the very earliest stages of that reauthorization process, Congress was asking itself a lot of questions about if the Bernie cases, and it's not just Bernie, but all the subsequently decided cases, had affected Congress's job, really, in assessing this provision. One of the things that I was struck by was that during a Senate hearing, the first Senate hearing, the chairman of the Judiciary Committee, Arlen Specter, in his opening statement, spoke about the way in which Bernie and Morrison and the other cases had put the court in the position of grading Congress on its homework. And he was not, obviously, he was not all that pleased about the advent of these cases and what it meant for the separation of powers. And I think we today are focused both on the federalism pieces, what it means for the federal government as against the states, but also what it means for the separation of powers, and that's a particular focus of this panel. I want to talk about what Congress was looking at as they began this reauthorization process. First, they had their own institutional expertise. Congress, as we've heard, has enacted a whole range of statutes over a very long period of time in the area of voting to protect the right to vote. And it really was not until the Voting Rights Act that these provisions and turning back the scourge of discrimination in voting took hold in any effective way. So the history of measures that were ineffective is part of what informed Congress, and Congress, having been engaged in this business since the time of Reconstruction, we've heard Cruikshank and other cases mentioned. Congress, having been engaged in this particular business since the time of Reconstruction, allowed it to accumulate a very substantial amount of institutional expertise. But it wasn't just its institutional expertise. The Supreme Court, as we've also heard, has opined about the constitutionality of Section 5 of the Voting Rights Act very decisively in the Katzenbach case, but again after the 1975 reauthorization in City of Rome. And then there is a case that people don't focus on quite as much, which is the Lopez case out of California, which was an as-applied challenge to Section 5 of the Voting Rights Act. And in that case, the Supreme Court, after Bernie, turned aside in rather unceremonious fashion a constitutional challenge to Section 5 of the Voting Rights Act. So Congress began with its institutional expertise, but also with this guidance from the Supreme Court, but it didn't stop there. In the Bernie cases itself, Section 5 of the Voting Rights Act is offered primarily as the counter-example. As the court has struck down a number of statutes, they had to sort of announce some limiting feature to what could be a doctrine that could sort of overrun the separation of powers. If it is simply that the court and not Congress gets to decide how to enforce the amendments, there's not much left of the enforcement power at all. And so by way of counterexample, the court has specifically pointed to the Voting Rights Act, and Section 5 in particular, as a very important example of when Congress acted to meet a very substantial problem with a very substantial record and imposed a stringent remedy. I think that this is important because as Congress sits and decides that it needs to make sense of the Bernie decisions, it can only look to its own experience and the Supreme Court precedents and, of course, the contemporary record of the problem that they're facing. And the point that Steve has made about the court-centric nature of the Bernie decisions is very important as well. To the extent that the Bernie decisions do focus on judicial findings of discrimination, Congress would do well to look at the Supreme Court's decisions and pay them some regard. The problem with the Bernie test, because after you hear all of this, you sort of think, well, what's the problem? The reauthorization of the Voting Rights Act really should be a fairly straightforward exercise. But the problem is that when you look through what Bernie requires as a matter of constitutional interpretation is that first it requires that the right be identified, the right or rights and issues be identified, then that the court look to the gravity of the harm with regard to the historical experience, and finally is that congruent and proportionality, that congruence and proportionality piece that causes, I think, the most trouble in the Bernie cases. And on the first two pieces, we're pretty clear that the Voting Rights Act puts us in good ground during the reauthorization, because the rights are voting and racial discrimination, very high order rights in our constitutional system, which grant more latitude. Certainly the historical experience is there as well. But when it comes time to determining what, after those two findings, is the most appropriate way to address the problem, that is something that I think the legislature needs to have a certain amount of deference to proceed on. And in this circumstance, one of the reasons that the court-centric notion of evidence is so problematic is because there has been, for 40 years, a very powerful prophylaxis in place. That prophylaxis has blocked but also deterred substantial amounts of discrimination, so that we have not seen, because of the success of Section 5, the same number of constitutional findings of discrimination. And so that was one of the questions that was tricky. How do you translate this court-centric view of Congress's job and power in a situation where you've been living with a statute that's been doing a substantial amount of work and has caused tremendous progress because of its existence, not in spite of it? That was one of the questions with which Congress was faced. And it really changed what Congress did. I'll close it down, but I just want to say it changed in some respects what Congress did. They spent an enormous amount of time on the reauthorization of the Voting Rights Act. There were over 21 hearings. There were over 46 witnesses. The record, I believe, is over 17,000 pages long. There was a very elaborate review of objection letters, which is the technical name for the way DOJ rejects discriminatory changes, and other evidence. And they really spent a long time going through the record. And they did all of this during 2 wars. So they were thinking a lot about how they can speak to the court in a way that the court will understand in the context of voting. And it wasn't just about the Voting Rights Act. It really was about the gauntlet of whether or not Congress retains enforcement powers. And that was part of the dynamic. It was important for Congress to speak authoritatively and decisively, to take its work seriously, but to do so in a way that took account of the court's signals that the game had changed in some respects. Happily, I will leave the discussion of the court case for the Q&A.
Thank you. Next, we have Pam Carlin of Stanford Law School.
Yeah, well, I also want to thank the organizers of the conference. I feel a little bit a statement that a mentor of Davo and mine, Elaine Jones, used to say at this point in a conference, which is, everything has already been said, but not yet by everybody. So I get a little chance to talk. And this is a conference about the second founding, but when it comes to really thinking about congressional enforcement power under the Reconstruction amendments, we have to talk about the second Reconstruction as well as the first, because our understanding of the provisions of Section 1 that are being enforced by Congress is not the same understanding of Section 1 that they would have had in 1870. And so let me give you just one very pointed example of this. To the second founders, it would have made no sense to talk about congressional power to enforce gender equality. Because after all, these are the men who wrote into the 14th Amendment itself, and the one part we haven't really talked about yet, which is Section 2 of the 14th Amendment, the Reduction of Representation Clause, which affirmatively sanctioned discrimination against women and was one of the causes of the wedge issue, to go back to Serena's point from this morning, which is a number of women who had been quite involved in abolition work before the Civil War got off the bus when it came to the 15th Amendment and the 14th Amendment, because the 14th Amendment wrote into the Constitution the right to disenfranchise women and not pay a penalty. So to them, it would have made no sense to talk about a case like Hibbs, because they would not have thought about the Equal Protection Clause protecting women in the way that we do today. So what I'm going to talk about here is why ought the court today, in light of the new understandings of equality and liberty that came out of the civil rights movement, the women's rights movement, the movement of LGBT people, and other movements of the second Reconstruction period, why ought the court today to defer more than it does to congressional decisions about how to enforce liberty and equality, particularly enforcing liberty and equality against the states? And I want to focus here on three related points. The first is a point that could be put in originalist terms in a sense, and that is the congressional centrality under the Reconstruction amendments. After all, they are the first amendments that add to the Constitution a specific textual provision that says this part of the Constitution is to be enforced by Congress. Why did Congress put this in there? Not just because they were worried that the southern states would later get taken over again by redemption as they were, but also because this was a Congress and a polity that was writing against an understanding of the Supreme Court that seems very alien to those of us who grew up as the grandchildren of the Warren Court in some way. After all, the framers of the 14th and 15th Amendments remembered all too well that when the Supreme Court defined liberty under the Due Process Clause of the Fifth Amendment, right before the Civil War, they said, due process and liberty and property requires the perpetuation and the maintenance of slavery by the government. So they would have been quite reluctant to cede to the Supreme Court the right to think all on its own about what does liberty mean, what does equality mean, what kinds of property is the Constitution going to protect. Second, any wholesale realization of the Reconstruction Amendment's principles of equality and liberty, however they were initially derived, depends on congressional action. Because litigation alone, that is the thing that the judiciary participates in alone, is unlikely to achieve equality or liberty. Without congressional enforcement, and really vigorous congressional enforcement, even a sweeping rights declaration like many of the ones from the Warren Court would have been far less effective. So consider here just a few examples. The dismantling of Jim Crow in Southern education came about not because of Brown against Board of Education alone, but because the Civil Rights Movement persuaded Congress to enact Title VI of the Civil Rights Act of 1964. It was the threat of federal funds cut off, and it was the and the use of the spending power as well as the enforcement power of the 14th Amendment that ultimately desegregated Southern universities and schools. Similarly, and this ties in with David's point, in 2 years, nearly as many black people were registered by federal examiners appointed under enforcement provisions of the Voting Rights Act of 1965 as had been registered in the previous century through all the litigation that had occurred. Title IX is another example of this. If you think about women's equality, it's not that the Supreme Court first came up with strict scrutiny and then Congress started enforcing. It's that Congress started enforcing and then the Supreme Court developed strict scrutiny. It is no accident that Title IX is 1972 and United States against Virginia doesn't come around for another 20 years. So let me turn now to my final point, which I think takes us back to some of this thinking about the original Constitution and the new Constitution. And here, I want to talk a little bit about Dred Scott for a moment and the following point from Dred Scott, which is, in the course of explaining in Dred Scott why black people could never become members of the political community formed and brought into existence by the Constitution of the United States, the Dred Scott Court relied, among other things, on a statute that was passed by Congress during the War of 1812. And the statute forbid, and I'm going to quote here, from and after termination of the war in which the United States are now engaged with Great Britain, the employment of persons other than U.S. citizens or persons of color natives of the United States. Now, the Dred Scott Court focused on this distinction between citizens and persons of color, which ties in, I think, interestingly with some of the discussion in the last panel about the relationship between citizens and persons. But I want to focus on a different part of the statute, which you may have lost as I read it to you, which is its treatment of the United States as a plural noun. Right? The Dred Scott Court says, after termination of the war in which the United States are now engaged with Great Britain. Just as the Civil War and the Reconstruction Amendments repudiated the antebellum view of African Americans as outside the political community of citizens, so too did the Civil War and the Reconstruction Amendments transform the United States from a plural noun to a singular one. And that is a big change. And yet the current Supreme Court thinks instead of looking at that as our fundamental change, that we should look to the 11th Amendment. Which, after all, even an illogical constitution, the numbers are consecutive. The 11th Amendment came before the 14th Amendment, and we might think the 14th Amendment therefore restricts it. But what we have seen over the last several years with the Supreme Court is the 11th Amendment has come to restrict the 14th. I've started calling this the 11th Amendment. And I think that's part of what we need to respond to, this idea that the Constitution is moving backwards in some sense, because just as we can celebrate today some of the triumphs of the Second Reconstruction, we need also to worry about a second redemption and not be fooled into thinking, because we've had some major transformative changes in this election, that we're not going to see a Supreme Court resistant to those changes and one that tries to restrict the enforcement clauses of the Constitution.
Okay, thank you. So I'm going to open it up for questions. Our panelists have given us a lot of good things to think about. I think, one, the question, a lot of strong information about the issue of whether or not Congress can reach private action, and also the implications of Bernie for both the relationship between courts and Congress and courts and state. One thing, I mean, I'll just hope that maybe people can get at this in their answers to comments, is I'd be curious to know if anyone disagrees with the standard that's set out in Bernie, and where people would put themselves on this continuum between a very narrow view of congressional power under Section 5 is there to remedy, okay, no one's going to adopt that position, but we're versus the other end of the spectrum, which is Congress can put in its own independent judgment, even after that may differ from what the court views. I think I know where Steve is on it, but I want to get at the issue of who people disagree with Bernie versus Flores on that. But with that, I'll open up to questions. Trevor.
Trevor Morrison from Columbia. So, you know, one of the dilemmas, obviously, in the Section 5 power is the state action syllogism. But the other that Pam referenced and that Alati just did too, right, is the relationship between the court and Congress and how not just whether rights can be overprotected in some prophylactic measure, but how they're defined. So the problem of Kimmel and Garrett, right, that because the courts implement equal protection with respect to those classifications by means of the rational basis test, that Congress has to understand the meaning of equality as to age and disability through that very deferential test too. And, you know, so there's plenty of scholarship showing why that's all wrong from Post and Siegel and others. Justice Breyer's dissenting opinion in Garrett lays it all out. So far it's lost, and it seems like that's a huge stumbling block to a more robust Section 5 power now. Not in the Voting Rights Act area, where even there the courts agree, right, that the underlying right is one that triggers greater judicial care. So in a sense, the apparent turn recently, too, in cases like Hibbs and Lane, I don't think should give us any confidence here, because those are as to categories that the courts have blessed as deserving of greater judicial solicitude. So if that's a big problem to overcome, that is somehow loosing Congress from the judicially used decision rules for implementing equal protection, it's unclear to me why looking back to the rich period of Reconstruction would help, in part for the reasons Pam has pointed out, right? We're talking about regulating to enforce the 14th Amendment with respect to classifications that would have been deemed non-14th Amendment events altogether, very likely. And so if it's right that this sort of interpretive supremacy of court over Congress is part of the things that, one of the things that's really limiting Section 5's power today, it seems that unlike what history could tell us about the sort of error of the state action syllogism, this dilemma is not one as to which we should be particularly hopeful that history can help. Question mark.
Okay, why don't we collect two more questions? Yes.
Thank you. I'm Bill Ewing. I'm a practicing lawyer in Philadelphia. I'm interested in Professor Calabresi's suggestion that that there's an affirmative obligation in equal protection, and that equal protection, and he talks about it in the context of the Violence Against Women Act, goes beyond just what might be protection, equality on the surface. And in fact, it seems to me that if this is right, it justifies affirmative action. Because when you see that people aren't really being treated equally, even though all the principles, the laws are neutral on their face, doesn't this say that equal protection, doesn't this view of equal protection require, in fact, affirmative action?
Okay, so one more. Richard? Oh.
Richard Primus, University of Michigan. I think the question is principally for Pam. It takes off from where Trevor is, but maybe with a more optimistic bent. And the question goes like this. Several years ago, we lived in a world of Lopez and Morrison and the beginnings of the Bush administration. We now live in the world of Hibbs, Lane, Gonzalez against Raich, and the beginning of the Obama administration. So the question is this. Given the reach of the Commerce Clause under Gonzalez against Raich, and assuming that Congress is willing to go through the drafting exercise that would be required to exploit the reach of the Commerce Clause under Gonzalez against Raich, what is there other than the 11th Amendment stuff, which let's stipulate exists as a problem where it obtains, that Congress could do if we got Section 5 right, that Congress can't do now? And if the answer is not very much, then okay, maybe doing this stuff through commerce rather than 14.5 is cockamamie from an ex-ante design point of view, but only in the same way that doing stuff through due process rather than privileges and immunities is cockamamie from an ex-ante design point of view. And another way of saying that is these other ways of doing it, commerce, so forth, like, that's the Constitution we have, so it's good to know the history and to learn something about path dependency to figure out how we got here, but do we really have such a big problem?
Do you want to go, Rebecca? Okay, then go. Pam,
Well,
it's on you.
The answer to your question, Richard, it comes out of the fact that there's been this profound change in the 20th and into the 21st century, which is a lot more people depend directly on the government, and if they can't sue the government, announcing the right under the in other words, announcing a liability rule under the or a regulatory rule under the Commerce Clause that can't then be enforced by the victims, the intended beneficiaries of the regulatory rule, who are victimized by the failure of a state to live up with that rule, is a pretty big deal. That is, if most people who work in the healthcare field are working like Ruth Garrett in public hospitals, then saying to public hospitals you have to comply with the Americans with Disabilities Act, but people like Ruth Garrett can't enforce it, depends on the political system enforcing it, right? So what you have when you allow the regulation under the Commerce Clause, but you then use the 11th Amendment to bar enforcement, is a huge regulation remedy gap. And that's what matters. But you're right. Otherwise, you know, the court has backed off so much on the Lopez-Morrison front after Raich that you can do almost any kind of regulation you want under the Commerce Clause. The problem is, how do you enforce that? And Congress has made a judgment, which I think an appropriate one, that private attorneys general are most likely to enforce this fully. And the Supreme Court, using the 11th Amendment, is extremely resistant to that. So that, you put your finger on exactly the problem, which is why I ended by saying that the 11th Amendment is the real problem here, and it's not Bernie standing alone, because I don't think Bernie standing alone makes all that much difference. What it is Bernie when used in conjunction with the 11th Amendment.
Yeah, I wanted to respond to Bill Ewing's question and also to Trevor Morrison's question. I guess in terms of the Equal Protection Clause, as I was trying to explain in my opening remarks, I think it's a clause about the protection of laws that are already on the books. And so it goes to the enforcement discretion of executives about laws that are already on the books. The Privileges or Immunities Clause is about non-discrimination in the making of laws. So I do think there is an affirmative right if there's a law on the books against murder or assault. I think one has an affirmative right not to have that law selectively unenforced for your benefit because you belong to a racial minority or some other kind of minority. But it's a limited benefit only for the enforcement of laws on the books. Does that lead to affirmative action? I don't think so. I think most of the affirmative action cases the Court has decided have involved the making of laws rather than the question of the equal enforcement of laws that are on the books. The issue about whether legislatures can make laws that are affirmative action laws, I think that question basically turns on the question that the last panel was debating about whether the rights protected by Section 1 can be overcome by general laws enacted for the good of the whole people, and whether one thinks affirmative action laws are general laws enacted for the good of the whole people or not. Obviously, there's disagreement about that. So I guess I don't think my view of the Equal Protection Clause as creating an affirmative right to protection leads to necessarily saying that affirmative action is constitutionally mandated. I think the key thing to remember about the Equal Protection Clause is that it's about protection of the laws, and equal is just an adjective. The noun is protection. That's what the clause deals with. On Trevor Morrison's point about is originalism of any help in creating or recognizing new suspect classifications, I think it's indirectly of some help. I think the fact that the 14th Amendment doesn't specifically talk about racial equality, but forbids all abridgments of privileges or immunities of citizenship, does mean that the 14th Amendment forbids systems of caste or of class-based lawmaking. And I don't think it's necessarily the case. I think that if one could have asked the framers of the 14th Amendment in the 1860s, does their forbidding of class-based systems of legislation ban European-style feudalism or, say, the Hindu caste system, I think they might well have thought that those things would be prohibited. In terms of how we interpret the ban on caste today, I think the extension of the ban to sex discrimination is explained not, as Pam was saying, simply by social movements in the 1960s. I think it's explained by the adoption of the 19th Amendment, whereby the American people conclusively say that women deserve equal political rights with men. Once we've given women equal political rights with men, it's very hard to explain why they shouldn't have equal civil rights as well under the 14th Amendment. Can the ban on caste expand beyond sex discrimination? Clearly, potentially it can. It can apply. It could be argued to apply to sexual orientation discrimination on the grounds that that's simply, as my colleague Andy Koppelman has argued, a form of sex discrimination. It may apply more broadly than that. I guess I don't think that Congress can simply identify new suspect classes and force the court to recognize them. But I think if the society as a whole comes to understand something as being a new suspect class, then Congress can recognize that and the court can recognize it either in enacting legislation or deciding cases.
But I thought Trevor's point was slightly different, which is I thought Trevor's point was, why does it have to be a suspect class for Congress to say we think this is an important form of equality? That is, Congress, why couldn't Congress pass a law tomorrow that says something about treating poor people the same for some particular reason and use its Section 5 powers? Now, you know, Richard's point is, well, they'll use their Commerce Clause powers or they'll use their Spending Clause powers because there has been no judicial pushback on Spending Clause, and the pushback on commerce seems to have abated. But the question is, why couldn't Congress say, we think, for the following things, we think that people's status as immigrants shouldn't be held against them, or we think people's status as poor people shouldn't be held against them in this way. So we're going to require the state to treat poor people the same as rich people on the following thing, i.e. give everybody free IDs in the state. Right? If you're going to have voter ID, we're going to use our 14-5 power to enforce equality, where we say poor people have to be given the IDs for free. That wouldn't require you to say poverty is a suspect classification, right? You would just say, we think equality here requires. And so that's, I think, one of the things that I found most unsatisfying, though I like the results in cases like Hibbs and United States against Georgia and, Tennessee against Lane. I like the results there, but the results there are not giving much respect to Congress. They're just saying, we've already said this, and so you can do a little bit of mopping up at the end for Congress. And I think enforcement, even under the readings you gave from the dictionary, enforcement is more than mopping up.
Yeah, I guess the counter argument would be that it's easy to see how, given the history, the 14th Amendment outlaws systems of caste or class-based legislation. And it's also, I think, fairly easy to see, thanks to Michael's work, how the 14th Amendment protects fundamental individual rights. I'm not sure that efforts to legislate against certain distinctions on the ground that they're irrational, I'm not sure that can be rooted as easily in the history of Section.
Well, I do think if you look at the 14th Amendment, this goes back to Pam's point, there's this curious thing, and basically when they talk about married women, for instance, in equal protection, and, Hale is objecting to this equal protection provision, and he says, well, if you can do this, you can give equal rights to married women. And the answer from Stevens and others is, well, the difference is distinctions between men are irrational based on color, and they're not irrational based on women. So how do you deal with the 14th Amendment today? Well, they have a principle, and then they have an application. And their principle is a good principle, and their application no longer makes any sense, so it's reasonable to go with the principle rather than the application. There's nothing in the 14th Amendment that says we will, and I think equal protection is about classifications in the law as well as the other, and you see that in Howard's speech and others, but there's nothing in the 14th Amendment that says no suspect class, as understood by the court, shall be denied equal protection of the laws. It's no person. So I think it's a very good question as to why Congress can't say, and really, if you want to talk about caste, I wonder if poverty isn't the most extreme caste we have today. That poor people are really our new caste system, more so than any other group. And so if we can get at caste and that sort of thing, I don't understand why we can't say, well, poor people have to have free voter IDs so they can participate in the political process. And also in Section 2, there's a good thing about Section 2. The bad thing about it is the male thing. The good thing about Section 2 is it's designed as a universal suffrage, male suffrage provision. And now that women have been enfranchised, so Stevens and the others clearly say, what does this mean? This means if you cut out any men from voting for any reason, your representation will be reduced.
Except that, if I could just interject there, the other thing is the Supreme Court by now would have struck down felon disenfranchisement but for Section 2 because...
Well, that's the negative thing about it. But if you look at it after the Civil War...
That, it's,
but if you look at it after the Civil War, if they'd really enforced Section 2, the representation of all these states that were disenfranchising blacks would have been way, way down. This is a section that should have been enforced, and now that women are enfranchised, it should apply to women too. And it should mean that if you shrink the electorate in any way, like voter ID, and you use it to shrink the electorate, fine, you should lose some congressional representation.
I wanted to get Dabo in on this point of, is the problem really the 11th Amendment and not Section 5 itself? Because would that suggest that given the 17,000 pages of testimony, yes, it took a lot of congressional time, but you would suspect that Section 5 of the Voting Rights Act, that is safe, right?
Yes, I do think that it's safe. But I guess part of the question, and this is where we move into the case that is now on direct appeal to the Supreme Court from an opinion authored by David Tatel and signed on to by Friedman and Emmett Sullivan in the DDC. The question is, what if the court takes the case and doesn't summarily affirm, and I tend to think that the opinion is thorough enough that the court could very well summarily affirm. And one substantive thing about the opinion suggests that even apart from the Bernie cases, that on the basis of the 15th Amendment enforcement powers, the Voting Rights Act, Section 5 of the Voting Rights Act, can be upheld constitutionally, and you don't even need to get into the 14th Amendment question because it's race and voting. There's an alternative holding that does the Bernie analysis and similarly finds that the act is constitutional. But there's a question about how much that case will tell us, because it is race and voting, about the larger issues. There's a way to, even if the court takes the case, there's a way to draft the opinion rather narrowly and sort of treat the Voting Rights Act, as the Bernie opinions have to date, as sui generis in a sense. That wouldn't do a lot to address the broader problem. But what I'll say from a race perspective, picking up on Pam's point about the Commerce Clause, I find it hard to believe that with the difficulty that we have had to vindicate racial equality through the amendments that have been expressly designed and enacted for that purpose, that if we were to untether that effort and try and proceed through a different part of the Constitution, that would work out well in the final analysis. It may be that the question was just going toward other types of legislation that wouldn't involve race, and I think Pam's answer stands there. But if the question is, what would legislation to protect racial minorities look like coming through a different clause, I think that the court would find a way to make that create mischief.
With two voting rights experts here, I have a voting rights question, and that comes out of North Carolina. It's the Pender County case. We used to have very racially polarized voting. Now we have a situation in which if you have about 40% black voting age population, or maybe even 38%, you'll have enough crossover Democratic votes so that the people the blacks support will win, typically. But our court, and it looks like the Supreme Court, is about to say, oh no, that won't do. You have to have at least 50% black voting age population, which is a method of diluting the black vote. So it looks to me, from my perspective, that in one of these ironies, the Voting Rights Act is sort of upside down now, and it's a method for putting as many black people as possible, up to 50%, in one district so that you can reduce their influence in other districts, even though they'd be able to achieve what you hope to achieve under the purposes of the Voting Rights Act.
I'll leave it to the moderator.
Okay, well, I think it would be great to have a panel about influence districts versus packed districts. But I'm going to allow you to answer that, but I do want to take just one last question, and then you can answer that in whatever sum-up comments. Rebecca.
That over the years, blacks and other minorities have achieved so much through the political process and then have it knocked down by the courts. You know, especially considering the fact that when I was in law school, I was taught that courts are supposed to protect minorities. And given that this is the case, I guess I would say in terms of, you know, the program of where do we go now, you know, November 14th, 2008, and into the Obama administration. One, legislation, trying to get legislation, and focusing more on legislation than on the courts, than litigation, I should say. And two, my criteria, my number one criteria for Supreme Court justices, in case anyone who's doing, you know, cares at all, who's doing any work with the Obama administration, starting to think about who those people might be, would be people that actually believe in politics and don't assume automatically that courts are better than political branches. You know, people that recognize that real lawmaking goes on. I think that we have such a supremacist court that that's, to me, the worst thing about the Supreme Court. So that's what that and as young as possible.
Any comments on that? Okay. Yeah.
Yeah, I'd just like to say I substantially agree with the first part of what you said about people who appreciate the value of the political process. And I think that one of the key problems in the court's Section 5 cases, including City of Bernie and United States against Morrison, is that the court is much too convinced of its own supremacy and of the importance of its own role, and it's not deferential enough. And so I would second that.
Well,
I've got to leave to catch a plane.
yeah, I was going
And
to
so
say.
I'll call Pam up and the other panel member and see if I can get an answer to my question.
Yeah, I'm sorry to cut off the answer, and I've been given instructions that we have to end. So thank you very much, and thank the panelists. Sorry, I couldn't get to